Good morning, everyone. Welcome to the third session of the Citibank BIAC International University Arbitration Contest 2022, organized by Bangladesh International Arbitration Center BIAC and supported by Citibank Limited. I am Krishna Khan, Assistant Counsel of BIAC, and I have the honor to be with you throughout this session this morning. BIAC had launched an inter-university arbitration contest in 2020 for students of law of Bangladesh universities. 2021, the contest was more broad-based, with participation by universities beyond the borders of Bangladesh, with the generous patronage of the Citibank Limited. The contest aims to acclimatize the participants with the theoretical and practical knowledge of the arbitration process and groom them to be better equipped national inter-university arbitration contest for the third consecutive year. As in the past, the contest will be conducted online. However, the final will be held in person. This year, 8 leading universities from home and abroad are taking part in this contest, which are last year's champion University of Dhaka, Bangladesh, the London College of Legal, the South Bangladesh, Kathmandu University, School of Law, Nepal, Bhuyan Academy, Bangladesh, North-South University, Bangladesh, University of Barishal, Bangladesh, Newcastle Law Academy West, Bahariya University, Islamabad. In each round, every team will consist of 4 to 6 students from each university. Each team will comprise of students with the roles of coordinator, counsels, and witnesses for their respective sides. For each team to present their cases. First session on 12 November 2022 and 20 November 2022. Now we are in the third session of the preliminary round, where University of Dhaka, Bangladesh is competing as claimant against the team of University of Barishal, Bangladesh as respondent. Before we move to the main contest, it's my pleasure to introduce the 6 participants from University of Dhaka and University of Barishal. Representing University of Dhaka, Nazia Tasnim, Rubaya Islam Ruhi, Abdullah Bukhari, Abdul Awal, Muhammad Faisal, Zarin Tasnim Rahman. Representing University of Barishal, Sadia Nourin, Asaduzzaman Idris, Amadul Hassan, Muhammad Moinu Ahmed, Sushmita Zamal Disha, Anika Tabassum Zinia. I would request both the teams to introduce their respective roles at the start of the contest. Both teams have already submitted their submissions to the arbitrator of the session and other party. We have already circulated the program of the session. I would like to request our today's arbitrator to strictly follow the time slots that is mentioned in the program. This is to ensure that both parties get equal opportunities. I would like to start the event by introducing the Chief Executive Officer of BIAC, Mr. Kaiser A. Chaudhry. Mr. Kaiser A. Chaudhry joined Bangladesh International Arbitration Center on 1st February 2022 as its Chief Executive Officer. Mr. Chaudhry holds a master's degree in economics from the University of Dhaka and is a professional banker. Having started his career with Greenleaf Bank in 1975, he held several senior positions in the banking industry, including positions of Deputy Managing Director and Managing Director of the country's 3 commercial banks, and also officiated as the Principal of Training Institute of Dhaka Bank Limited. Currently, he is in the Board of Premier Bank Limited as its Independent Director. I now request Mr. Chaudhry for his welcome address.
Thank you, Krishna. Much respected Colonel Dinesh Kumar Bishnoi, arbitrator of today's session, distinguished guests and dear participants from University of Dhaka, Bangladesh, and the University of Barishal, Bangladesh. Good morning, a very good morning to you all. It is indeed a great pleasure for me to welcome you all to the Citibank BIAC International Inter-University Arbitration Contest 2022. It is also my privilege to reiterate our gratitude to the Citibank Limited for sponsoring this important event of BIAC. It is a matter of great pride for Bangladesh International Arbitration Center, BIAC, that it is hosting the annual Citibank BIAC International University Arbitration Contest for the third consecutive year for university-level students, with an aim to familiarize the participants with the theoretical and practical knowledge of the arbitration process, to groom and shape them into better equipped legal professionals. Moreover, in course of this contest, students will get an opportunity to acquire practical knowledge of alternative dispute resolution and develop necessary rhetorical skills, and furthermore, stand to benefit through the delivery of advisory notes by top regional and global professionals in the field of ADR. In 2020, BIAC launched an university arbitration contest for the first time for law department students of the universities in Bangladesh, which was organized online in the wake of COVID-19. In 2020, BIAC arranged a more broad-based international contest with online participation by students of 7 national and international universities. The event was aptly titled as the Citibank BIAC International University Arbitration Contest 2021, being held under the generous sponsorship of the Citibank Limited. The contest, first of its kind in Bangladesh, was held in digital platform the last quarter of 2021. A few words about BIAC. BIAC is the first arbitration institution of the country. It is registered as a not-for-profit organization and commenced operations in April 2011 under a license from the government of Bangladesh. The International Chamber of Commerce, Bangladesh, the World Business Organization, Dhaka Chamber of Commerce and Industry, and Metropolitan Chamber of Commerce and Industry, Dhaka, are the sponsors of BIAC. The International Finance Corporation, the private arm of the World Bank, with funds from UK aid and European Union, had supported BIAC during its initial stages under a cooperation agreement. BIAC provides a neutral, efficient, and reliable dispute resolution service in this emerging hub of South Asia's industrial and commercial activity. BIAC aims to embed the use of ADR as a commercial best practice to facilitate creation of an ecosystem that fosters investment and is conducive to business. BIAC is committed to be a credible and a sustainable national institution that aims to offer international commercial best practices on ADR services to individuals and institutions seeking to resolve commercial disputes. Since its inception in 2011, BIAC has received the recognition of 62 national and international institutions, including the Permanent Court of Arbitration, The Hague, the Netherlands, and many other international ADR centers, local corporate companies, financial institutions, real estate companies, NGOs, universities, and law firms in Bangladesh. About membership, BIAC offers membership to practitioners, stakeholders, students, and interested individuals at home and abroad to create a knowledge and resource sharing platform. A few words about outreach programs. BIAC organized 155 workshops, seminars, and webinars till the present date. Although COVID-19 has frustrated holding many of its events, BIAC hosted a number of webinars jointly with its local and regional partners. BIAC also organized a national consultation session based on the request of the Law Commission, Bangladesh, on proposed Arbitration Amendment Act 2018 by Law Commission, Bangladesh, and the recommendations from the session on the proposed Arbitration Amendment Act 2018 were sent to the Commission. BIAC has proposed to the University Grant Commission and the Bangladesh Bar Council to introduce ADR in the academic curriculum in order to raise awareness and popularize this alternative dispute resolution procedure within the country. UK Foreign and Commonwealth Office recognized the role of BIAC in their publication, Bangladesh Doing Business Guide. This guide is for British businesses who are interested in developing overseas trade in Bangladesh. US Embassy also recognizes BIAC as a forum for its resolution of US citizens' trade disputes and have enlisted BIAC in the process. Once again, our sincere appreciation for the generous support and contribution of the Citibank Limited, as well as the continued enthusiasm of the academia and the students to participate in the contest and making it a successful one. Thank you all and best wishes to the participants. Thank you.
Thank you, sir. May I now introduce our today's chairman of this session. We are extremely honored to have with us Colonel Dinesh Kumar Bishnoi. Colonel Dinesh Kumar Bishnoi is registered with Bar Council of Maharashtra and Goa and now practicing at Bombay High Court, Mumbai. His practice includes litigation, arbitration, mediation, adjudication, and conciliation in almost all areas and sectors, including international maritime arbitration. He has completed his Bachelor of Law in International Law and Labor Law, apart from diploma in Senior Level Defense Management. Advocate Bishnoi has acted as a sole arbitrator, co-arbitrator in a number of commercial and contractual arbitration cases. During his entire distinguished and illustrious career for 39 years, he has been awarded twice by the Honorable President of India. Advocate Bishnoi has been empaneled as an arbitrator in several international ADR centers and also achieved accreditations from different ADR institutions. Now it is time to start the contest, and I would like to hand over the floor to the arbitrator of the session to start the contest. Colonel Dinesh Bishnoi, Kumar Bishnoi, the floor is yours.
Good morning, Mr. Chaudhary. Thank you so much for your address, and you have always been motivating the students, and I'm happy to be part of the ADR movement of the Bangladesh with all of you. And it is my proud privilege to be acting as arbitrator in this competition. Now, let us welcome the participants of the day. Okay, now the competition has moved to and has progressed quite a bit. And I don't think that I have to remind the participants about the time and the sequence. So I would expect the teams to remind their participants. I had earlier also highlighted this aspect that in the international arena, you guys have to be self-disciplined. There should be none reminding you about your sequence or your time slots. So I will now hand over to you. Sequence is known to you and timings are known to you. So on that note, may I request you please start. Thank you and wish you all the best.
Honorable Arbitrator, much obliged. I was supposed to do the introductory speech on behalf of the claimants team as the coordinator to allocate our roles. May I proceed with that first, Honorable Arbitrator?
Yes, please.
Much obliged, Honorable Arbitrator. A very good morning to you all. I'm Zarin Tasnim Rahman, the coordinator of the claimants team. I, along with my teammates, shall represent the claimant BIAC PLC in this arbitration proceedings between BIAC PLC as the claimant and Dampier Limited and Vectorville Limited as the respondents. We have in total 6 members in our team. We have 4 counsels and 2 witnesses. Counsel Abdulawal will present the opening statement for 10 minutes, and he will also conduct the cross-examination of respondent's sole witness, Mr. Alom Mia. I, Counsel Zarin Tasnim Rahman, will conduct the examination in chief of the claimant's first witness, Mr. Parvez Chaudhary, for 10 minutes. And as I have already mentioned, I shall coordinate the session. Counsel Abdullah Bukhari will conduct the examination in chief of claimant's second witness, Mr. Harun Rashid, for 10 minutes. Counsel Tasnim will submit the arguments and summations for claimant at last. As to the witnesses, Honorable Arbitrator, Ms. Rubaiya Islam Ruhi will play the role of claimant's first witness, Mr. Parvez Chaudhary, and Muhammad Faisal will play the role of claimant's second witness, Mr. Harun Rashid. Honorable Arbitrator, we humbly seek your permission to share our screen from time to time in order to refer to the relevant documents and pinpoint relevant information. May we please have your permission on that regard?
Yes, please.
Much obliged, Honorable Arbitrator. Honorable Arbitrator, I would like to draw your kind attention to one particular issue, that the respondents have provided only one witness. As per the BIAC guidelines as provided to us, we are given 20 minutes for cross-examination. Thus, we humbly request you to permit us to conduct the cross-examination for 20 minutes, Honorable Arbitrator. May we please have the permission?
I have my visions on this. I would like to hear the other party before deciding on this factor. So may I invite the other party, the opposing team, to please comment on this?
Honorable Arbitrator, we thought the only witness we provided is more than enough to make the counsels, opposite counsels, the claimant to understand that the claim they're asking for is not valid. So we thought one witness is more than enough. And for their claim that they want to cross-examine our witness for 20 minutes, I think according to the rule BIAC made for us, I think 10 minutes should be for one witness. So we have one witness, and you should go strictly through the rules that specific one witness will get 10 minutes for the examination. But we humbly request that whatever the Honorable Arbitrator chose, we will obey it. Thank you.
Thank you so much. And I feel that the time given for one witness cross-examination is 10 minutes, and we should adhere to that. And we should continue adhering to all those stipulations, and we should not stretch or interpret to suit our own convenience. I request both the parties to please abide by those. Thank you.
Much obliged, Honorable Arbitrator. Now, with your permission, we would like to call upon our first counsel, Mr. Abdulawal, to start with his opening statement. Much obliged, Honorable Arbitrator.
Yes, please.
Sorry if I may interrupt a little bit. Excuse me. In regards to the time limits allotted to the witnesses, even if there's one witness, they can use 20 minutes. If you have like 4 witnesses, you have 20 minutes. So it's not that one witness would be allotted just 10 minutes.
Okay, fine. If the BIAC interprets in that manner, we have no problem. Myself and both the teams will follow that. Thank you.
Much obliged, Honorable Arbitrator. Now we would like to call upon our first counsel, Mr. Abdulawal, to start with his opening statement. Thank you so much. Much obliged, Honorable Arbitrator.
Honorable Arbitrator, may I proceed with my opening statement?
Yes, please.
Much obliged. Good morning, esteemed presence. I'm Abdulawal, counsel for the claimant Jasbi Bag. In today's arbitration proceeding between the claimant Jasbi Bag and respondent Damveer and Rector Veer, I shall be enunciating the opening statement on behalf of the claimant side. At the outset of the opening statement, I would like to submit a brief of the fact for the convenience of the tribunal and my further narration. Honorable Arbitrator, respondent to Rector Veer is a patent holder of certain vectors. In 2014, they entered into an exclusive agreement with Gauss Pharmaceuticals for research and development of vaccine for malaria. After its accusation by Zoctes, as shown in Exhibit 5, Respondent 2 signed an exclusive agreement with Respondent 1, Damvid, which is another subsidiary of Zoctes, for the commercialization of the very God-outcome vector. In November of 2018, Respondent 1 offered God-outcome vector to the claimant, as shown in Exhibit 7. While the negotiation was ongoing with Damvid, Panna Roy of Rectory took over the negotiation, as shown in Exhibit 9. Despite the claimant side's objection, he suggested using the old template of Rectory and further added additional purchase obligation in Clause 16 as provided in Exhibit 14. The respondents also assured regarding IP rights in Clause 11 of our agreement. The claimant side, in good faith, entered into the agreement. However, on 1st May 2019, the claimant became aware of an ongoing dispute over the scope of the GOS agreement, which covers the claimant's interest. Over this justifiable threat, the claimant side asked for clarity, as shown in Exhibit 20. In response, the Damvid CEO played down the situation, and this was accepted by the respondents in page 6 of their submission. Further, respondents were involved in a backdoor discussion with GOS over COVID vaccine. Despite repeated attempts, they didn't address claimants' fundamental concerns, as shown in Exhibit 24, 25, and 26, constituting breach of contract. Attempt for amicable settlement failed due to non-compliance and cooperation from the respondents, and as such, we have come to the BIAC Arbitration Tribunal under Clause 14 for declaration of breach, enforcement of a specific performance, and compensation. Honorable Arbitrator, for your ease of reference and tracking, further statements have been portioned into procedural and substantive parts. Under the procedural part, since both parties are in consonance regarding jurisdiction, seat, language, and cost of the tribunal, I would not narrate it further. The claimant submitted its arbitration request on 22nd November. Honorable Arbitrator, for substantive part, we have 6 key points to address. First, the dispute liability between the claimant and the respondent falls solely on the respondent. Second, the PCL agreement covers exclusively virus-based respiratory diseases, including COVID. Third, the claimant abided by the agreement. Fourth, the respondents have violated good faith and fair dealing of the agreement. Fifth, the respondents are liable for breach of contract. And last but not the least, the claimant is entitled to get remedy for the breach. Mr. Arbitrator, sir, before coming to the substantive point, we would like to state that the respondent's submission has been vague and ambiguous on crucial substantive points, causing difficulty in comprehension for the claimant side. Now, being patent holder, Rectory signed an exclusive agreement with GOS, citing malaria and other infectious diseases as shown in Exhibit 4, and had full knowledge of it. Despite that, Panna Roy of Rectory assured us of IP security. As such, in the current dispute, Rectory can't escape liability. The same Rectory signed exclusive agreement with Damvid to market the God-outcome vector. And as such, Damvid offered the vector to the claimant as shown in Exhibit 7. Despite that, Rectory's Panna Roy took over the negotiation dubiously and later backslided on IP assurance, which goes against Article 3 of the TRIPS Agreement. Sir Arbitrator, in respondent's submission, they claimed that there is not a single company which solely owns a vector. It contradicts with the fact as Rectory itself owns certain vector, including God-outcome and Char-outcome. Moreover, US Patent Office has recently granted Gentisol Company an exclusive patent for a vector used for breast cancer cure. For reference, it is patent number 909 Patent Office. Further, Honorable Arbitrator, there's a difference between malaria and other parasitosis diseases, virus-based respiratory diseases, including COVID-19, as shown in Exhibit 3, 29, 30, and 31. Sir Arbitrator, in both respondents' exclusive agreement, there was also malified intentional overlap. By using for all application except malaria, quote unquote, the respondents extended the scope of Damvid to commercialize the vector. Whereas in the GOS agreement, they included other infectious diseases, quote unquote. In this regard, Samir Sardana versus Internal Security Division is referred. For the second substantive point, both parties agreed in Article 2 of the agreement that the claimant was allowed to use the vector for research and development of vaccine for infectious and non-infectious respiratory diseases. The respondent assured regarding IP right claim concerning third party in Clause 11, but later backslided, including having backdoor discussion, despite the claimant's repeated attempt for clarification as given in 17, 20, 24, and 25, which again violates Section 17 of the Patent and Design Act. We humbly submit to the Honorable Arbitrator, sir, the veil of Zoctes, as both respondents are 100% subsidiary of Zoctes. Moreover, while the claimant was negotiating with Damvid, Rectory's Panna Roy took over negotiation. His such action demands lifting of the corporate veil as provided in Section 199 of the Company Act 194. Within their submission, they have also referred to Pfizer vaccine being available in December 2020. Arbitrator, in what context they brought this fact isn't clear to us, as Pfizer has got nothing to do with the current dispute. Having said that, Pfizer was available in US, not the international market, whereas we're dealing with Bangladeshi context with companies established under Bangladeshi laws. Moreover, Pfizer vaccine used mRNA vector, whereas we are dealing with Goracticum vector, which is a DNA-based vector. Thirdly, Reverend Arbitrator, sir, the claimants are abided by the agreement during the full period, and there is no contention over it. Even the respondents did not contend over it. Despite addition of a peculiar clause 16 in the agreement, the claimant side focused on developing a vaccine using the Goracticum. I'd also like to refer to doctrine of adhesion, section 73 of the Contract Act, and the case of Hadley versus Baxendale. Fourthly, sir, the foundation of any agreement is good faith, mutual trust, and fair dealing, as emphasized in section 37 of the Contract Act. Our agreement was not alien to that. Rather, it is apparent that the respondents were alien to this notion. As such, Damveer and Rectorveer kept the claimant in dark, suppressed information during the negotiation. Honorable Arbitrator, sir, the link between GAUS and our agreement is the respondents. In both the agreement, Rectorveer is a common party, with Damveer playing a significant role. As such, for dispute between the claimant and the respondents arising out of GAUS agreement, it is the respondents who can only be held liable for playing both sides, which goes against the Paris Convention. Moreover, their single affidavit exhibit doesn't have any evidentiary value, where they have preposterously alleged that the claimant has bribed national reputed newspaper, the Business Standard, to publish partial news article as shown in Exhibit 5 without any substantial exhibit or factual basis. Fifthly, sir, Damveer and Rectorveer assured regarding right, and for a startup which is focusing in one product, existential significance. The respondents kept the claimant in dark despite the bona fide endeavor by the claimant, as demonstrated in Exhibit 20, 24, 25. However, sir, Article 25 and 30 of the UNCIGS imposes duty on the party to deliver goods which are free from any IP right, which are free from any right of a third party, which at the time of the conclusion of the contract, the seller knew or could not have been unaware of. The respondents also frustrated the contract by engaging in a backdoor discussion. California Company versus SM Corporation is also referred in this regard. And last but not the least, sir, we humbly submit the title to get damages and have the agreement specifically enforced under Section 12(3) of the Specific Relief Act, and reference of a 2000 case of Surjit Kaur versus Navrata Singh is added. As the claimant side performed, and there is no contention in this, the respondents have double played, causing significant damage to the claimant with justifiable threat over his hard-earned research. Due to malintention and non-performance by the respondents, the claimant side has starts. Arbitrator, sir, this was our humble submission.
With your counsel would to proceed examination in chief of claimant's first witness, Mr. Parvez Choudhury. May I please proceed with the examination in
Yes,
chief?
please.
Much obliged, Honorable Arbitrator. Mr. Parvez, am I audible to you?
Yes, counsel, you're audible.
Mr. Parvez, please introduce yourself to the Honorable Arbitrator for record purpose.
I'm Parvez Choudhury. I'm 36 years old and currently working as a Chief Operating Officer for BIAC Pharmaceuticals, and I'm the licensee and first party of the purchase, collaboration, and licensing agreement.
Can you please tell what are the job responsibilities in BIAC PLC which are relevant to this agreement and dispute?
Well, as a COO, I handle the functions of chief executive and manager at the same time, to design, to implement policies, to promote the company culture and vision, and to oversee the day-to-day operations to keep the business on track, come under my job responsibilities.
Mr. Choudhury, please tell the Honorable Arbitrator about the purchase, collaboration, and license agreement and how the process of the agreement started.
Well, viewing one of our advertisement posters in one of the social media sites in September 2018, as far I can remember, one gentleman called me and discussed about an agreement regarding the use of Goracticum viral vector for the development of a vaccine against respiratory disease. Later, we communicated through emails, and after several set of negotiations and discussions till December 2018, finally we concluded the agreement and signed it on 1st January 2019.
Mr. Choudhury, can you clarify to the Honorable Arbitrator as to when and how did Panna Roy got involved in the negotiation?
Well, as I have mentioned, we were discussing about the contract document prepared by Damveer, and at that time, Mr. Hassan Mahmood was the contractual head of Damveer. He was communicating with us, and we were discussing that such kind of template was not suitable for such kind of transaction. At that time, Panna Roy called us on 3rd December. 2018, and he mentioned that he was nominated by Zoctis as a new head of contract for Damveer Limited. And later on 18th December, as far I can remember, Mr. Panaroy met first time with me in my office along with a Zoctis official to finalize the negotiations. And in December 2018, when he took over the negotiations, he was still working for Rectorville Limited. And he himself suggested us that our further discussions should be based on the template used by Rectorville Respondent 2 for their collaboration and licensing agreements earlier. And instead of amending the original draft, he suggested us to use that template. And finally, on 1st January, when we signed the contract, on the same day, Mr. Panarai became the new contractual head for Damveer.
Mr. Chaudhary, why do you think Respondent 2, the Damveer Limited, was connected and liable in the entire matter?
Well, since Rectorville is the patent holder and the licensor got the authority from the patent holder upon which they later entered into the agreement with us, and also through Mr. Pannaroy, who has earlier been working in Rectorville, and during negotiations of the purchase collaboration agreement, he joined Damveer and entered with us in the discussions to finalize the agreement.
Okay, Mr. Chaudhary, my next question to you. Since you have mentioned that while taking over the negotiation, Panna Roy was still working for Rectorville Limited. So at that time, did you know about GOS agreement through Panna Roy?
Well, not really, not really. During negotiation, we asked them about the exception malaria and about why it is put in the terms and conditions. And then respondents informed us that they have earlier licensed out Goretcam, but for only malaria purpose to some other company. And they never particularly mentioned any name to us.
Okay, Mr. Chaudhary, can you please clarify to the Honorable Arbitrator, why do you think that research on COVID-19 falls within your scope under this agreement?
Well, Counsel, respiratory disease is a type of disease that affects the lungs and respiratory parts of the body, causing cough, shortness of breathing, chest pain, etc., as has been expressed by WHO worldwide. So since COVID-19 is also caused by SARS-CoV virus that affects the respiratory system, causing breathing difficulty, coughing in most of the people, so research on COVID clearly comes within our research agreement.
Mr. Chaudhary, what is the reason behind the recent conflict between your company and the respondent company?
Well, we were going on pretty smoothly with our research on COVID-19, but on early May, or maybe it's 1st May 2020, I came to know from an older article in Biopharma Science that there was apparently a dispute between GOS Pharmaceuticals and Respondent 2 regarding the scope and reach of GOS agreement back in 2014. And it was obvious from the article that the GOS agreement was about malaria and other infectious diseases. So once I came to know about the dispute from the article, it clearly put us in a threat that all our hardcore research might get at risk with an IP claim. So I immediately contacted Ms. Aliasha, the CEO of Damveer, to clarify the situation, but she somehow played down the problem.
Okay, Mr. Chaudhary, why do you consider the discussion between GOS and Zoctis as a threat to your company? Or if I rephrase the question to you for more convenience, how do you think Zoctis is involved in the entire matter?
Well, Zoctis is the mother company of Respondent 1 and 2, and Zoctis entered into the discussion regarding the scope of GOS agreement, but the GOS agreement was between Rectorville and GOS, and not between Zoctis and GOS. So it appears to us that the holding company is interfering into the matters of subsidiary company. And also earlier, Mr. Pannaroy informed us that he was nominated the contractual head for Damveer by Zoctis. And thus Zoctis is controlling the internal matters of subsidiaries, like choosing the contractual head, discussing about subsidiaries' previous agreement. And all of this creates a concern in our mind that something is being done behind the corporate veil to defraud a small startup company like us. And It also creates suspicion in our mind and a threat that licensor might not perform their part since they seem to be under the control of the mother company.
Mr. Chaudhary, as you have mentioned about the probable IP claim, so what was your reaction after knowing a probable IP claim or a previous overlapping IP?
Well, as I have already mentioned, we tried to contact them through email to wipe all our suspicions and concerns immediately, but they either played down the problem or never even bothered to reply to our emails. We thereafter tried to informally connect through some common personnels like Ms. Hannan to sit and amicably settle the issues, but they also never seemed to be interested to amicable settlement as well.
Mr. Chaudhary, my last question to you. If in any way BIAC becomes unable to commercialize the vaccines, how that is going to affect your company?
Well, as a small startup company, first of all, we cannot even imagine to think how that is going to be held. We are with limited funding and manpower. We left all our other projects and we have concentrated entirely only on this one project since the licensor's conduct assured us that we should continue with our research on COVID. And we have already due 7 crore, including the 5.5 crore that we invested in the research of COVID instead of paying for the first batch. So in such a situation, if we are barred in any way, be it breach of contract or be it IP claim to commercialize the vaccine, it might shatter the very existence of the claimant company. At such an emerging peak of our new company, we cannot even imagine of how to face it.
Okay, Mr. Chaudhary, thank you so much for answering the questions with patience. Honorable Arbitrator, if I sum up the answers given by Mr. Parvez Chaudhary, we can find some key points as to the relevancy of the claim on behalf of the claimant. Number 1, Panna Roy was involved in the entire matter and he is the bridge through which respondent to Rectorville Limited is also liable, as per the answers given by Ms. Ruhi. Mr. Parvez Chaudhary. And secondly, Honorable Arbitrator, Zoctis as the holding company of the respondents is involved in the entire matter. And if we sum up, the acts of respondents expressed a considerable threat to the claimant, BIAC PLC. Mr. Parvez, did I say all the points in accordance with your answer?
Yes, you're correct, Counsel.
Thank you, Mr. Parvez. Honorable Arbitrator, no further questions from my end. Thank you so much. Much obliged, Honorable Arbitrator.
With the permission of the Honorable Arbitrator, I would like to start cross-examining the first witness of claimant. Please.
Yes, please.
Okay. I noticed that the claimant counsel addressed you as Miss Ruhi. Please state your name and profession once again for the record.
I'm Parvez Chaudhary. I'm 36 years old and I'm currently working as the Chief Operating Officer for BIAC Pharmaceuticals.
Chief Operating Officer, right. Okay, Mr. Chaudhary, how long do you have been working as the CEO at the company?
Well, I have been working for 2 years now. I have been working for since the very starting of the company, BIAC Pharmaceuticals.
Okay, you were with the company from the beginning of the company started. Okay, all right.
Yes.
Did you ever have any other job other than the corporate job? Because you're 36-year-old and this company isn't that much older. So did you have any other job other than corporate?
Yes, I have earlier worked in the similar kind of companies and thereafter joined the BIAC Pharmaceuticals.
Okay, that takes me to the next question. You mentioned at your statement, and I quote, one gentleman called me and introduced himself as the deputy head of the contract in a reputed R&D company, and you asked him to share his ideas. How could a suspicious company as you are a small startup and you recently started, discussed potential business with someone you didn't know? And before that, answer me this: how could you not know the great Panna Roy? Honorable Arbitrator, Panna Roy to the corporate world is what Tom Hagen was to Michael Corleone at The Godfather. Yeah, please.
Well, counsel, I'd like to draw your kind attention that in my statement, I have mentioned that we later found that the person who called us was Mr. Panna Roy. Since he called us in a representative manner from a research development company, and we did not conclude the entire agreement on phone. We just informed them, we just replied them that they should contact us through mail so that the conversation can be an official one. And that's what we did later. And in the email, you can find the designation of Mr. Panna Roy.
Okay, I understand. Okay, as the licensee of the first party, what exactly were your duty? What did you do as a licensee?
Could you kindly rephrase the question, counsel?
Okay, as the licensee, you had to you were the executor of the license agreement from your end, your company's end, right?
Well,
So
as a CEO or COO, I was involved in the licensing agreement.
okay, so did you ever point blank ask the licensor about the exclusivity of the agreement?
Well, agreement clearly is in section 2 about the scope of the agreement, which clearly mentions that this licensing agreement would be an exclusive license. So both of the parties obviously know this since both of them signed the agreement.
Okay, so is this the first time or I mean, your company executed any agreement with another big company before us?
I'm sorry, Mr. Counsel, I don't know how this is relevant here about my previous work, but
Okay,
as a pharmaceuticals company, we had to deal with different agreements with different countries since we research, develop vaccines and commercialize them in different sectors. So we had to engage in different agreements and licenses.
okay. Before I go to my next question, let me tell you how this is relevant, because you in your entire request for arbitration, you kept saying that you are a small startup and you are suspicious, and this kind of loss, you can bear more than one loss this big, and you can't handle more than one operation. So I think it is relevant that if it's your first time, because if you can handle this kind of big negotiations. So that's why. Okay, so do you know that how, okay, do you know that how giant companies expand so much, or do they get so much profit? Because they grow together, they're dependent to one another, they lend favors to one another. But we get that you wouldn't understand, as a small startup, you don't have the resources to handle more than one one operation at a time. So this is very normal that we have other agreements with other companies, which time to time might seem like they're overlapping your agreement. And companies like Rectorvid doesn't prosper by dishonoring their agreement. But did you ever go? Okay, is this the first time with Rectorvid as a licensee, or did you do any other researches with them before that?
Well, Mr. Counsel, first of all, I'd like to correct you that we never mentioned that we were not able to handle. We could, but we wanted to research. We wanted to concentrate entirely on COVID-19 since the world was entirely affected with COVID, and developing a vaccine on COVID-19 was the prime concern for us. We never said that we could not handle other projects. This shows our concern and our obligation and our respect for the agreement, and not like we could not handle.
With all due respect, Mr. COO, I didn't mean you cannot handle more than other projects. I meant more than one project at a time. Okay, so your whole round of dispute is a blog of journal that mentions that you might not have exclusivity in that agreement, and you requested for arbitration just because Rectorville Limited didn't treat you as their sole client?
Not at all, Mr. Counsel. Not only the suspicion from the article, I guess you can see for our email conversations, but also not only the article, and also their entire course of conduct. They're not replying to our concerns, suppressing information about a previous agreement, GOS agreement by Mr. Panna Roy, who had the entire knowledge of the GOS agreement, who had the knowledge that there might be an overlapping IP, and also the previous license regarding infectious disease, and also interference by the mother company Zoctis. All of this put us into a serious concern that the respondent might not perform their part, and also put us and leave us putting in a threat of IP claim. And Our existence might be at risk. So all of this validly concerned us.
Okay, I do not have any further questions, but Honorable Arbitrator, to sum up this, I would like to just say one thing. If the father has to assure the son that he will get the inheritance every time he's concerned about it, father cannot do anything else other than making him sure that he will get the inheritance. That's all, Honorable Arbitrator, from my end. Thank you.
Honorable Arbitrator, if the Respondents' Council has no further questions, shall we proceed?
Yes, please.
Much obliged, Honorable Arbitrator. With your permission, Counsel Abdullah Bukhari would like to conduct the examination in chief of claimant's second witness, Mr. Harun Rashid, for 10 minutes, and Muhammad Faisal will play the role of Mr. Harun Rashid. Much obliged, Honorable Arbitrator.
Good morning, Honorable Arbitrator. Am I audible? Dr. Harun Rashid, would you please turn on your camera and microphone, please?
Am I audible and visible, Learned Counsel?
Yes, you are. So, Mr. Harun Rashid, please state your name for the record purpose.
Myself, Harun Rashid.
Okay. Could you please tell us about your job distinction?
Currently, I am working as Deputy Chief of Drug Testing Laboratory in Bangladesh Drug Administration.
Okay. So, what are your job responsibilities in Bangladesh Drug Administration?
There are various responsibilities. Some of them are specified various statutory enactments like the Drug Act 1940, the Drug Rules 1945, Ordinance related to drugs and the National Policy of 2016. Moving on to the responsibilities, these are prohibition of manufacture and sales of drugs without supervision of pharmacists, and also to review under licensing agreement, as well providing green signal authorization. Last but not the least, control of advertisement and claims in respect of drugs.
Okay. So, Mr. Rashid, have you ever heard anything about the GOS agreement?
Yes, I heard. It took place between Dactravir and GOS Pharmaceuticals in 2014. Both of them are registered under Bangladesh Drug Administration.
Okay. So now, do you have any idea about the purchase collaboration and license agreement of BIAC?
Yes, I know about the purchase collaboration and licensing agreement of BIAC, which was concluded between Danby and BIAC in 2019.
Okay, so as you know about both of the agreements, could you please distinguish between these two agreements?
Yes, but I cannot tell you the differences. So for my job is concerned, I will only tell you the relevant portion which I am concerned with. As I have to review various license agreements to check the veracity of a license to permit the licensee to proceed with their activities, I have found that both of these agreements are concluded for the same viral vector named Goretcam viral vector. But the licenses given are not same. The GOS agreement was concluded for malaria and infectious diseases, whereas the BIAC agreement was for respiratory diseases. Thus, the field of use in GOS agreement is comparatively wider. On the other hand, the BIAC can use the viral vector in the field of respiratory diseases only.
Okay, so Mr. Rashid, do you think the term comparable or mere infectious disease cover the respiratory diseases also?
Yes, the term infectious disease is wide enough to embrace the respiratory disease within the ambit of it.
Okay, now tell me, can GOS work in the field of respiratory disease?
Yes, they can, as the term infectious disease also includes respiratory diseases, and COVID is that's all.
Oh, okay. So as GOS can work on these respiratory diseases, now tell me, GOS can claim any IP restriction regarding this sector?
Yes, they can claim IP restriction if any third party uses their contracted viral vector in that very specific field for which they are granted the license.
Okay, that's fantastic. Can you please tell me, as an expert on this field, that what happened if any third party advance with such an IP restrictions?
Well, normal scenario is that the basic work of that very company against whom the claim is filed is get stopped, And if it is their sole field of work, obviously they will face heavy loss upon a justified claim of IP restriction.
Okay. Do you think any sort of IP claim or restriction regarding the GORAD-CAM viral vector and non-conforming will cause any irreparable damage to the claimant?
Certainly, you cannot sell the single product of same function to multiple buyers. That if I consider JSP and GOS as two buyers, then the licensor Danby and patent holder Rector cannot give the license to both of them for a same purpose. It is against the general object and scheme of such type of agreement.
Okay. So if such restriction is about to be invoked, then in your opinion, whom to blame for such an act?
While if any third party proceed with IP claim, then it is obviously the liability of the licensor and patent holder. They have to clear this point. If there is any chance of possible IP violation, then victim company can contact them for making immediate action and settle the issue.
Okay. So now tell me, Mr. Rashid, whether non-cooperation to clarify the third party claim regarding the contracted viral vector gives any liability?
Of course, the licensor or patent holders always provide assurance regarding third-party IP claim in any sort of exclusive license. And when any third-party claim is bloomed, then it is their liability to clarify the issue. Otherwise, it may amount to deviation from their main contract. This sort of deviation may amount to breach of warranty.
Okay, so Mr. Rashid, I have one more question for you. What is common scenario for a newly established startup when a third-party dispute regarding an IP restriction is bloomed?
Well, as you have said, a newly established startup, it is obvious that it will be a burdensome situation for them. You know, there is always a shortage of manpower resources in such sort of newly established startup. So it can be easily deduced that the restriction will not strike their business lightly. Perhaps it will put them in existential crisis.
Thank you, Mr. Haruna Rashid. Thank you for your cooperation, Honorable Arbitrator. I have no further question for Mr. Haruna Rashid, but if I sum up his statement given, there are two very clear points to be mentioned: that the respondent has breached the PLC agreement with the claimant and breached the confidentiality, good faith fraud, cause fraud, and suppression of information. That nothing but the specific performance of the contract can be a proper remedy for the claimant. That's all from my side. No further question. Thank you, Honorable Arbitrator.
With the permission of Honorable Arbitrator, can I cross-examine the witness, please?
Yes, please.
Okay. Please state your name one more time.
Myself, Haruna Rashid.
Okay, and what do you do at the office? Like which office do you hold?
I'm currently working as Deputy Chief in Drug Testing Laboratory in Bangladesh Drug Administration.
Deputy Chief, okay. Which university you have graduated from in public administration? Like, did you ever study public administration?
No, I didn't.
You didn't? I can see you've put a lot of degrees before your name in your statement, all specialized in life science. How would you describe your experience as an administrator at your present office? Like, what do you do?
Well, I'm now I'm not currently working as administrative. My before experience, it was quite good since it was related to my field of work. And you know, in every office there must have a administrative portion. So you cannot just imagine that all of those administrative offices will be handled by expertise having a public administrative degree.
Okay, I understand. So as a scientist, I guess you organized like 5 or 6 junior scientists in your lab. How small is this organization? They made you the deputy chief of the company?
Could you please repeat your question?
Yes, you kept mentioning that you are a small startup, but how small?
learned counsel. You are maybe deviating from the main portion. I'm a witness from Bangladesh Drug Administration. I'm not concerned with the works of BIAC. I have no relation with them.
Yes, I understand. But I really don't have any question for you about the contractual agreement of
Then how can you ask me about BIAC?
But you're testifying that
Yes, I'm testifying those facts which I'm concerned, but I'm not aware of the portion of BIAC.
Okay, all right. So let me ask you this. You said in your statement, and I quote, the primary dealings regarding the viral vector between Gos Pharma and BIAC PLC were identical. Still, the use was distinctive accordingly to the agreements. They were bound by Rectorville Limited and Damville Limited, respectively. I repeat, you use the word bound by. How did you come up into this conclusion? Before that, please let the honorable tribunal understand why is even a scientist testifying about administration and contractual obligation and not working in the lab for the welfare of humanity. And I think we heard enough about your expertise in administration. Let's talk about what you're really an expert in. Please tell us from your expert opinion, if a small startup like BIAC PLC, who cannot handle more than one operation at a time, could they be actually successful on making COVID vaccine before Pfizer came up with the vaccine before them, or they're making it an excuse on a simple dispute, a probable dispute of the license agreement, that they would be able to invent the vaccine and industrialize it?
Honorable arbitrator, I would like to object on behalf of the claimant side that the respondent counsel is stating something which is hypothetical, and it is not related with our our witness too, who is an official of the DGDA. So his statement that could the claimant could produce vaccine or not is not anything matters or concerning our witness too. So it is irrelevant, and also it is hypothetical. It does not concern our witness too, who is an official, government official of DGDA, and it is also to rectify it is also to inform the respondent counsel that the respondent, our witness too, is an official, government official of the DGDA, Directorate General of Drug Administration. So your questions regarding, hypothetical questions regarding contract or regarding the BIAC, that whether they could produce it or not, is not relevant to our witness too. You could have asked this to our witness one, who is official of BIAC. But this is an impartial witness from the government that we have produced. Thank you, Honorable Arbitrator.
Okay, with all due respect, Honorable Counsel, I think your whole request for arbitration is hypothetical. But all right, I don't have any other questions on for him. But to sum up my questions, I would like the Honorable Tribunal to consider the witness that he doesn't have any credibility talking about business strategies. If BIAC really making the scientists take over the, if BIAC really would...
Honorable Arbitrator, may I please object on this matter? Honorable Arbitrator, I think Mr. Counsel did not go through the witness statement we have given. And one more thing, that they might not aware of the function of an previous administrative officer of Bangladesh Drug Administration as well. And the deputy chief, as a deputy chief, before going through an examination or any test on a medicine, they have to clarify from the administrative officer that if there is any relevant contractual obligation or any other dispute regarding IP rights is there. So it's very much official for them to know about this. So I guess you can do a bit more homework on this to make yourself clarified. Thank you.
Thank you, Honorable Counsel. You mentioned clarify about medicine.
No. You are still getting me wrong. The function of deputy chief of a drug testing laboratory.
Yes, yeah, and you said we have to clarify about the medicine and its IP right.
No. Okay, whatever.
All right. The objections is overruled, and the hypothecation and hypothecatory approach is sustained. So I would request the counsel cross-examining the witness to be on the side of the relevancy, and the scope of the cross-examination is huge and vast. So let us give the counsel who's cross-examining his dues, please. Thank you.
Much obliged, Honorable Arbitrator.
Much obliged. I don't have any other questions, and I only request Honorable Arbitrator to deny his credibility on this manner, because the BIAC, they didn't come up with the vaccine. They only succeeded the first round, like first stage of the trial. So yeah, that's all. Thank you.
Honorable Arbitrator, I would like to object on this point. May I, Honorable Arbitrator?
Examination is already over, and I do not know whether you are objecting to what, but let me hear you. Please proceed.
Honorable Arbitrator, learned counsel of the respondent just stated that our witness 2, Mr. Harun al-Rashid, has no credibility, but he didn't clarify as to why he is saying this, that witness 2 has no credibility, because he is an official, government official of who deals with the administration and vaccine licensing. So I think he is wrong on this point, Honorable Arbitrator. Much obliged.
May I answer?
All right, I will cover this later, and let us proceed further with the process.
Thank you.
Much obliged, Honorable Arbitrator.
Good morning, dear all. I'll be the lead counsel of respondent team from University of Barishal, Anika Tabassum Jinia. I have my team of counsels with me, their examiner-in-chief, MD Mominu Ahmed, as an acting cross-examiner, Imadul Islam, and witness of respondents, Asadul Zaman, our first and only and most important witness. May it please the Honorable Arbitrator proceed?
Yes, please.
Honorable Arbitrational Tribunal, I am the lead counsel in the matter of arbitration under the BIAC Arbitration Rules 2019 of the Bangladesh International Arbitration Center, also and coordinator of the respondent team. The dispute is between JSPVAC PLC, who is the claimant, and Dangvi Limited, respondent number 1, and Rectorville Limited, respondent number 2. On behalf of the respondent, and I have the honor before the Honorable Tribunal, together with my co-counsels. Over the course of submission, I will submit the opening statements with facts that is relevant. Your Honorable Arbitrator, if I may proceed.
Yes, please.
Mainly, our respondent number 1 is a contract manufacturing organization of the Jockeys Group for producing pharmaceuticals-based material. Our respondent number 2 was a small startup trying to commercialize and conduct industry-funded research project using viral vectors for the development of a new type of vaccine, and a patent owner of Gore-Atcam viral vector, which is mainly the dispute is about. 15 June 2014, respondent number 2 sold an exclusive right and license to research and produce vaccine against malaria and infectious disease, which is arguable. After 4 years of gross agreement, August 14, Jockeys Group acquired respondent number 2 and its patents. Now the claimant is accusing us of violating the contract for sharing the license with our sub-company. Also, according to them, we infringed their right to solely research on their product and asking for monetary compensation, which is totally baseless, because I think the product and research is inclusive on their own, and we are sharing the license with one of our sub-companies. Apparently, a mother company may share, adopt, reproduce, develop any of their patented vector what he owns, where to our clarification, they first started the research on malaria and later on intended to do some business on ongoing pandemic. On top of that, they are expecting us to share every detail of our venture, business venture or research. We are not going to share every detail. And this is very insulting, that the words they're using, like we are playing double, or we are going to suppress their value, but we are not such a powerful giant company on all of a sudden. There's a well-known maxim of equity. He who seeks equity must come in clean hands. But they themselves violated the contract, honorable arbitrator. They were supposed to deliver respondent number 1, the first batch of Gore Atcom Vector, and 5.5 crore was due. Again, we owe them 7 crore of money for touching the milestone regarding the license. Not only that, they were supposed to buy HEK 2094 cells and culture medium from us, which they were compelled to buy from the contract, according to the contract from our company. But they, regardless to say, did not. Against all of their paper cuttings, we are going to submit that one piece of evidence that single-handedly questions the credibility of their stack of evidences. As an ex-employee of Daily the Business Standard, on a sore affidavit, how contagious YOLO journalism is, reporters print anything in search of content. I hope our claimant party is aware of that. We want to ensure that though we had differences, but in nowhere affected them financially, and no negligence on our part that could be avoided or overlaps anyhow with their research project. Our witness will be Mr. Aldomia, the respective Chief Administrative Officer of the respondent number 2, Director V Limited, who handles all the paperwork and patent permissions of the company. If Your Honor do not have any query about the facts, may my counsel proceed with examining the witness?
Yes, please.
Thank you so much. Much obliged.
Thank you, late counsel, and thank you, arbitrator. I would like to examine in chief Mr. Alomia, the Chief Administrative Officer of the Rectorville Limited. Please state your name and profession, please.
This is Mr. Alomia, working at the Chief Administration Office of Rectorville Limited.
My next question is, how are related with this dispute?
Okay. As a Chief Administration Officer of Rectorville Limited, I had to negotiations and dealing with others company as a part of the company's employee I involved in this dispute.
How would you describe the relationship with JSPFAC PLC and Rectorville Limited?
Okay. We had a very good relationship. We did business together for a long time, and we were very happy about it until they started second guessing our actions or credibility.
Okay, sorry for I hang off my cell phone. My next question is, how did you think they came up with the amount of the relief claim?
Oh, can you repeat, please? I can't hear you.
How did you think they came with the amount of the relief claimed?
Oh, as the admin of a leading company, I have friends liaise with administrative authorities in other companies too. So yes, I can answer your question. I recently had a chat with the CEO of Pfizer. He mentioned that they had a profit margin of the exact same amount the claimants sought relief. They're literally trying to compensate themselves from our pocket based.
Okay, so as you mentioned the fact, now I want to, what was the dispute about actually?
We, Rectorville Limited, sold JSPFAC the license for the use of Gore Atcom vector for the development and the production of malaria virus and infectious disease, but it was on their part to make and include product out of that. It was a mere permission, nothing else. The other company we sold it to got just the permission as well, but not the product. The permission does not make any difference to the original agreement. They may have their own difference, better product in the market. The other company built a product out of that. First, the Ghost Pharmaceuticals are now expressing their unjust anger on us, where it's a business venture and just collaborating with would stop us from keep the company running and vaccine the other company in lives. They're blaming us for not profiting on pandemic, which they intended to, and not even gain the name to invent it first. This is how it works on the corporate world, where we share our resources to make it easier for the small pharmaceuticals contributing on saving lives.
Okay. As you mentioned, Ghost Pharmaceutical. So now I want to ask you, how was your that means Rectorville Limited relationship with the Ghost Pharmaceutical company?
Now, on 15 June 2014, Ghost Pharmaceuticals good relationship with Rectorville Limited resulted in the Ghost agreement granting an exclusive license to use the Goret cam vector for malaria vaccine development and production.
Okay. On June 15, 2014, your company granted Ghost Pharmaceutical an exclusive license to use Goret-Cam vector for the production and development of the malaria vaccine under Ghost Pharmaceutical and Rectorville Limited. Biopharma Science in local journal of the startup published in 2020, Dhaka. Was there conflict between any, or what do you think is the reason for the publication of such news or its effect and how much?
But they're not sure what the news is talking about the dispute with Biopharma Science, Ghost Pharmaceutical. In the news, they say apparently or gaze-based, which can also be said to damage the reputation of the company. In the past, some people have spread false news that amounts to yellow journalism to tarnish the reputation of the company because the news they say is based on sight or gaze. They could not provide any proof.
Okay, that's mean you mentioned that it can be guess-based. My question is, why do you think Ghost Pharmaceutical claimed in the statement in 2021 the license cover research into effects and against COVID-19? What is your opinion on this?
Okay, Ghost Pharmaceutical has been granted an exclusive license to use the Goret-Cam vector for malaria vaccine development, research, and production. The later clarified the agreement in 2021, saying that the license also covers research on a vaccine against COVID-19. The research is mentioned here, but now if they invent something new while researching malaria vaccine, it is a matter of their interpretation. However, the agreement expressly granted an exclusive license to use the Goret-Cam vector for malaria vaccine development and production. Thus, for researching it and discovering something new is another matter.
Thank you, Mr. Alon. Thank you, your cooperation. That's all my side. There is no more questions. I think it's clear that the scenario scenario on the gate space not ensure. Thank you, Mr. Honorable Arbitrator.
Honorable Arbitrator, with your permission.
Before the claimant takes the floor for cross-examination, I would like to say something about the timing of the cross-examination, Honorable Arbitrator.
Yes, please.
Okay, about the examination of our sole witness for 20 minutes, the last document BIAC provided, it mentioned each slot separately for each witnesses, and they didn't mention like more than 2 slots for witnesses. So I think from our interpretation, the BIAC might think that 10 minutes is more than enough to get the answers what they're looking for from one specific witness. So and I would like to mention 2 points. One is our chief has a lot of responsibility in his office. We are not small startups like other companies. We have a lot of responsibilities. And other thing, I would like you to take it under consideration that the councils in Bangladeshi judiciary always takes the advantage of adjournment and other issues like that to delay the procedure of the courts and for the matter tribunals like this. Thank you. And I would like honorable arbitrator to reconsider this rule one more time. Thank you.
Honorable arbitrator, may I interject on behalf of the claimant side about the objection raised by the respondent side?
Yes, please.
Honorable arbitrator, as the council respondent stated regarding the guideline of BIAC, but since they have provided one witness, but there's time allocation of 20 minutes for 2 witnesses. And as the BIAC has, as you earlier stated, regarding the BIAC guidelines allowing, I would like to request that this is not a delay tactics. You're referring to delay tactics in Bangladeshi judiciary. Delay tactics, you can consider it if we request for postponement of witness cross-examination. We are not asking for that. We're asking in a single sitting, extra 10 minutes, which under the BIAC guide rules, we can ask for, as there was another extra slot for you to provide witness, you did not, and as BIAC provided, we can ask for it, and the honorable arbitrator considered it. Thank you, honorable arbitrator.
This issue has already been decided, and we had ruled and agreed that since the BIAC has clarified, they can take their entire slot and they can use the entire limit, and both of you have eaten your 2 minutes each despite that. Okay, so you please limit voluntarily. Proceed. Thank you.
Honorable arbitrator, on behalf of the claimants team, Counsel Abdulawal would like to proceed with the cross-examination of the sole witness of the respondents. Shall we proceed, honorable arbitrator?
Yes, please.
Much obliged, honorable arbitrator.
Thank you, honorable arbitrator, for giving me the floor to cross-examine the respondent witness. Based on your previous permission, honorable arbitrator, I'm sharing the screen to honorable arbitrator. The sharing screen has been disabled. If it could be activated so that I can share the screen for cross-examination purpose.
BIAC has to step in if that is possible. If that is not available, you may please proceed.
Thank you, honorable arbitrator. If I could proceed with the statement. Mr. Alam, am I audible to you?
Yes.
Mr. Alam, how are you today?
Fine.
Mr. Alam, you are the Chief Administrative Officer of Rectorville. Am I correct?
Yes.
Okay, so since you are on such a high post in Rectorville, you must have worked for a long time in Rectorville. I mean, I am asking for precise exact time. When did you join Rectorville?
Okay, as I am currently working as the Chief Administration Officer of Rectorville for a long time, and that is almost 3 years.
3 years from
Yes.
now. Okay, so you have been working for 3 years. As the Chief Administrative Officer of Rectorville, you must have heard, and in your chief examination, you have also stated about the GOS agreement. Are you aware of the GOS agreement?
Yes.
Okay, so you are aware of the GOS agreement. Mr. Alam, in your submission, honorable arbitrator, since I cannot share the screen, let me refer to it. In the submission of the respondent in page 6, you have claimed that not a single company owns a license for a vector. That has been that you claimed in your submission. But in page 5 of your submission again, in introduction of respondent to your company, Rectorville, you have stated that you own GORATCAM, CHARATCAM, and certain other vectors. Is it correct?
Not any other, just yes.
I did not understand. Can you please repeat again?
Not any other company you mention it, but only our company.
Yes, so, but I'm stating that your submission self-contradicts. On page 6, you're stating that in the world, you said that not a single company in the world owns own any kind of vaccine or the patent of it. But on the other hand, in introduction of your company, Rectorate, it itself holds patent of GORADCAM, CHARADCAM, and certain other patents. So why this self-contradiction? And also refuting the fact of the case. In page 1 of the fact of the case, it is clearly stated that you hold patent. And Honorable Arbitrator, I would also like to refer to the case of Gentisol Company. The US Patent Office has recently given them ownership of a vector to use for breast cancer purpose cure. As such, your claim is not viable, and it goes against the fact of reality and also fact of the case, and also self-contradictory. Can you please stand on it?
Okay, I can understand your question, but let me refresh my memory. I have to handle huge matters, so I can't remember at the moment.
You have to handle huge matter. That is why I'm asking you this question. You're the Chief Administrative Officer. So you must know why, when you, on one side, you're claiming that no single company hold it. And then again, you're using this as a big officer of the company that you do not know about this. This is not viable. Anyway, let me move ahead since I have time restriction. For clarification, you have, if I could ask you that you have in your written statement of the submission, you have stated a part, let me just read it out to you, that where it's a business venture and just collaborating with would stop us from keep the company running, and the vaccine the other company invented saved life. Can you please just clarify on this sentence, because we could not grasp the sentence, the meaning of it. What do you mean by the other company invented saved lives? Which invention saved life you're talking about here?
Okay, for that situation, it's need to research for the development of the vaccine, because
I'm sorry to interrupt you, but I'm precisely asking. You said in a written statement that the other company invented whatever they invented saved life.
Can I interrupt quickly, opposite counsel? Can you please be a little gentle and slow? Our witness is getting very nervous as he is not compatible with the tribunal ambiences in his daily life. That would be very much appreciated. Thank you.
Thank you, responding counsel. I will take that into notice. Thank you for your observation. Okay, let me just go slowly then. The vaccine the other company invented saved lives. I'm asking you to clarify your own statement that what company invented what and saved lives. Which company and what did they invent? What are you referring to here? Are you referring to Gauss?
According to the course of business, we have to do this at the time.
I'm sorry, since you're not responding to the precise question, let me just move ahead again. So, okay, in your statement, you also said that that it is on their part to make an inclusive product out of that. It is on their part. Whose part? Gauss's part to develop an inclusive product you're talking about?
It is just BIAC.
Just be back to inclusive product about it. Okay, so you in your chief, you stated also that you have given exclusive license to Gauss for malaria, but you did not mention that you have also granted them exclusive license for other infectious diseases. Did you not?
Please, can you repeat it?
I'm asking that did you grant exclusive license for Gauss only malaria, or for other infectious diseases?
Only malaria, not other.
But you are refuting again the fact of the case. You cannot refute the fact of the case. The fact of the case in page 2, Honorable Arbitrator, I would like to state, I would like to quote from here that the respondents have, the respondent 2 entered into collaboration agreement with Gauss Pharmaceuticals and exclusive license for the use of GORADCAM vector for malaria and infectious diseases, quote unquote. I'm sorry, you cannot refute the fact of the case. You gave them exclusive license, which include infectious diseases.
It is malaria and other comparable diseases.
Comparable, anyway, comparable diseases, comparable infectious diseases, I'm sorry. In page 4, it says comparable infectious diseases, not only comparable diseases. Okay, so since you accepted this, which is part of the fact, can you please state why this umbrella term did you use with Gauss? because Honorable Arbitrator, I would like to state here a section 4X of the Bangladesh Shankramok Rog Protirod Niyontron o Nirmula in 2018, which is the English for your arbitrator, the Infectious Diseases Prevention, Elimination and Control Act 2018, section 4X define infectious disease. And within that definition, any disease can be termed infectious disease if the government, through its gazetted notification, provides so. And as such, the DGHS, the Bangladesh Government's Director General of Health Service under Ministry of Health, on 17 April 2020, termed COVID-19 as an infectious disease. So I would like to ask you over this, Mr. Witness, that do you think that within the infectious disease of the GOS agreement that you allowed, COVID-19 falls within that infectious disease?
Definitely, Council.
Okay, so you are accepting that GOS can produce COVID-19 within the definition provided the infectious disease, right?
We never said they can.
You just accepted it, respondent, that you allowed them. It is part of the fact I'm stating. Let me rephrase for you. Is COVID-19 an infectious respiratory disease or not?
Can you please repeat it?
I'm asking, is COVID-19 an infectious respiratory disease or not?
He has an exclusive permission for the research
I'm sorry,
and development.
I'm asking you that is COVID-19 an infectious disease or not?
Yes, but it's not the clear clarification.
I'm sorry, you accept it. Thank you for your yes. Thank you for your positive answer. Within the government of Bangladesh and around the world, you cannot refute that COVID-19 is an infectious disease. And this infectious disease, under the Director General of Health Service, on 17 April 2020, through a gazetted notification, they termed COVID-19 as an infectious disease. So GOS, as you earlier accepted, within their agreement, can use the God-ARCAM viral vector for vaccine purposes, right? For using developing vaccine for COVID-19. You accepted it. Can you please respond?
With the permission of Honorable Arbitrator, the COVID-19 vaccine, COVID-19 is an infectious disease, and we never said you don't have any, you don't have the exclusivity. You are in the agreement. We have an agreement with you. But the other thing you are referring from the journal, you heard that it might have arise and dispute. It's not, you are not certain, you are asking from only from a journal article, and you think there might be a dispute, but there is not. So please please ask the other line of questions, because this is totally clear. We never said you don't have any exclusivity. You can produce it, and for the other agreement you think you do not have it, or it might both the two agreements are on the same gray line, but it isn't. So please move on to other questions. Thank you.
I'm sorry, Respondent Counsel, you cannot dictate me regarding moving on to other questions. I have to clarify.
I'm requesting. Thank you.
Okay, I'll get back to regarding the exclusivity that you have raised, but I'll have to confirm on the point. Honorable Arbitrator, the witness has accepted that COVID-19 is an infectious disease, and within they have allowed exclusive license, which include COVID-19 and other infectious disease. And under Bangladeshi laws we are discussing, infectious disease, any disease that the government term as such through gazetted notification, and COVID-19 has been termed so. Now let me move on with our part of the agreement. Since the counsel respondent has said that you never stated that we have an exclusive agreement, I would like to mention to you, I would like to refer to you your own submission, which is page 7, your claim B. I would like to read it to you. The claimant requested the tribunal to declare that the purchase collaboration agreement.
Just a minute, please. There is one hand being raised. Could we hear the objection?
Honorable Arbitrator, I don't have any objection, but through your permission, I would like to draw the kind attention of BIAC to share our screen if they kindly permit us.
No, I think we have already decided it is not working or disabled, so you have to proceed. Please proceed.
Okay, Honorable Arbitrator, I'm proceeding.
Permission has been given.
Okay, thank you. Thank you regarding that. Okay, thank you, Honorable. Let me just share the screen. Is my screen visible, Mr. Alam? Mr. Alam, is my screen visible?
Yes, it is visible.
Okay, so let me just move on to the part where just a few minutes back, the respondent counsel stated that they have not given us any exclusive license. So from your own submission, if I could refer, the counterclaims and the defense that you have provided, yes, if I could put your attention to this part, you have
May
stated—
I interrupt for a little to just clarify? It was exclusively for malaria and infectious disease, and comparable word was still in argument. I don't know why opposite counsel is repeating this over and over.
Okay, I'm stating comparable. You did not, the infectious disease, as I stated, the definition of Bangladesh's existing and enforcing law, infectious, even if you exclude comparable, within infectious disease, we can, within the GOS agreement, we can term COVID as an infectious disease. That's what I'm stating. I'm not debating on the comparable point.
Just a minute, please. Just a minute. What do you want to show in the screen? There's nothing visible. Only the PDF files are visible.
Honorable Arbitrator, I just shared the screen.
You shared the screen, but only the PDF files are visible.
Honorable Arbitrator, if you permit, I would like to share the screen on behalf of our counsel. Shall I?
You can do so, but nothing is visible as far as I can only see 4 PDF files.
Okay, I would thank you so much, Honorable Arbitrator. I would request Counsel Awal to stop his sharing so that I can share the screen.
I did stop. As long as my co-counsel Rahman shares the screen, I would like to state that in your claim B, you have stated that the claimant provides an exclusive license for the development of a vaccine for COVID-19, but technically it already does. So you accepted that you have given us exclusive license for COVID-19. The entire portion of the cross-examination that I have been going on is to provide that the respondent Rectorville, being a patent holder, independently first allowed GOS to use within its agreement by using the umbrella term infectious disease, COVID-19, and then later on, they have provided the same exclusive license of Coratcam, which falls also COVID-19. So there's an IP right clash on the side of the respondent, which witness one of the respondent accepted. Okay, let me just move ahead then. You have again and again stated the mere suspicion. In your first point of claim, you have stated that on mere suspicion, the claimant side has come to the arbitration council. Is it not?
Yeah, it was clear. Like
Mr. Respondent counsel, I'm asking question to the witness. Please let the witness respond.
Sir, please proceed.
Yes.
I'm asking you that you have stated that the mere suspicion, based on mere suspicion, we have come to the arbitration council. Is it?
Just a minute, please. I still can't see anything. I am now viewing the inbox. Now you have to show me something, otherwise close this share screen so that we can be visible to each other.
Honorable Arbitrator, with all due respect, we have like while working on a project, we have so many buyers and so many sellers from our end. Like if we want to produce one vaccine, we buy materials from many sub companies. Like we sub license from many companies. Like on this note, respondent one is one of the companies that that gave us the materials for the vaccination program what we are talking about, and we never said that they don't have the exclusive.
Just a minute, please. You know, I do not know who is speaking, because I can't see, and I have to see and hear who is speaking. And I think I have already made it clear, we all should be on one grade, that the scope of cross-examination is very huge and vast. And the witness must respond, and all the objections, clarifications, statements, explanations must come from the witness. And in case you feel otherwise, then you please let us know what is there in your mind which is getting agitated so intensely, please.
I understand, Honorable Arbitrator, but there is no dispute between the first licensing agreement, but they're trying to confuse us because they're scared of one particular journal that says that we might have an IP conflict. So it's already been 19
Okay, fine.
minutes.
By this tendency of intervention, we all are aware that there might be an attempt to educate and guide the witness, which is not permissible. So I would request that such interventions are avoided, and these are actually not permitted, because I have already explained to you that by such interventions, there is always a tendency to educate, guide, to steer the witness, which is not permitted. Please proceed.
Thank you, Honorable Arbitrator, for giving me the floor. Mr. Alam, so you have stated that on mere suspicion we have come to the arbitration tribunal, is it not?
Yes.
Okay, so let me just then let me just ask you a question on 3 points that based on what.
Let me now interject. There is another hand being raised by the BIAC. So let the BIAC state their point, please. I think it is by mistake. Okay, please proceed.
Okay, so I'm giving you 3 points based on that. Please justify that. Why is it you are claiming that on mere suspicion we have come to you? First, you didn't respond or communicate to our repeated communication attempt as shown in Exhibit 20, 24, 25, 26. Second, you did not cooperate during amicable settlement. It is due to your non-cooperation, the amicable settlement failed. And the third, the deterioration of your goodwill, as you claimed that it is the dispute is deteriorating your goodwill. If you're so concerned of your goodwill, then why did you allow this to be deteriorated to this level that we have come to the arbitration tribunal? Why did you not respond? Why did you not cooperate during amicable settlement? And why did you not cooperate? Based on what you're stating then, that is mere suspicion. You could have responded to us. You could have addressed our significant, crucial concerns, existential concerns, and this could have resolved. Why did you not do that? Honorable Arbitrator, I would like to also refer to our Exhibit 26, which is the last communication between us and the respondent, where we have urged them to abide by the agreement. And the fact of the case, where again they have refuted in their submission that it is us because of whose non-cooperation amicable settlement failed. Whereas the fact clearly states in the last page that it is their non-cooperation because of which the amicable settlement failed. So please respond, Mr. Alam, that why are you again and again stating that it is mere suspicion on again and again on these several points? You could have resolved it, but you did not. Why did you let it sustain to this level?
Learned Counsel, you are blaming me for no reason. We are always open to settle, but that can't be baseless.
You could have, okay, then you could have claimed that it is a baseless. It is a baseless. You did not respond. You could not show a single exhibit in your submission where you responded to us. Where are your exhibits? What are the base of your such claims that we are making baseless claims? Can you show any exhibit from your submission where you said that we are making baseless claims? This could have resolved it. You did not. Why did you not? And then you are complaining that we have come to the BIAC arbitration tribunal based on mere suspicion.
Learned Counsel, it's beyond my concern at the moment.
This is your concern. You're the chief executive, chief administrative officer. Okay, let me move ahead. You stated, chief, that you have talked with Pfizer's CEO, right?
Honorable Arbitrator, it's been 20 minutes already.
Honorable Arbitrator, I could not get my 20 minutes due to the interjection, repeated interjection. Can I get 2 more minutes?
Because of the screen problems and avoidable interjections, I am with the parties that we can allow, say, about 1 minute plus. Please wind up.
Thank you, Honorable Arbiter. Thank you so much. So you, Senior Chief, stated that you have talked with Pfizer CEO. Did you not?
Please repeat it.
You have stated that you have talked with Pfizer CEO. Did you or did you not? Regarding
Yes,
where
we
is
have
that?
a good relationship
Can you
and good
show that in
communication also.
Okay, so can you show that in your exhibit? Where is that exhibit? Can you show that in any part of your submission that you contacted with Pfizer CEO?
He is a friend of mine, and as of our business, we have a good relation, and we are sitting always.
So a friend of yours, you are bringing that in an arbitration tribunal. You have not exhibited this. Can it be valid that an informal discussion, you're bringing that as a base of your claim, and you have not added any exhibit regarding that, any official thing? Okay, let me move ahead. Pfizer, Honorable Arbitrator, Pfizer's and Goradcam's vector issue is completely different. Pfizer uses mRNA, whereas Goradcam is a DNA-based viral vector. Pfizer is a US company. We're not claiming monopoly over all vaccines of COVID-19. So it is not in what context they're bringing it, they could not connect it. Mr. Alam, I have last one question for you, that in your single exhibit of affidavit, you have referred to a person, Mr. Rakibul, who has, and in your opening statement, you have accused us of bribing the business standard, the exhibit 5 of the claimant side. Can you please tell us why the claimant side would bribe the business standard? What and how would they do that? Because the first interaction between you and us, between the respondent and the claimant, happened in November of 2018, whereas the Exhibit 5, the business standard article, was published in August of 2018. Why would we do so when we have no interaction? And furthermore, the content of the article was Zoctis acquiring your company. What is the interest for us to cause such rumor? And it is a fact of the case. How can you say it is a rumor?
Honorable Tribunal, we never said the claimant bribed him, but we mentioned that maybe the publisher of the journals, they sometimes exaggerate.
All right. Both the parties to tell me whether they have run out of time. If yes, maybe maybe go for winding up.
What, Honorable Arbitrator, let me just since you have let me just wind up in 1 minute. Then that I would like to end with the
already 25.
I would like to end with a single exhibit that they have provided, Honorable Arbitrator, that is not admissible and that is not credible, because in an affidavit, in a legal forum, the affidavit has to be signed by the person who is making it. The particular affidavit that they have added is not signed by a person in which magistrate court it was presented, or no attachment or acknowledgement has been added with the exhibit. Furthermore, Mr. Rakibul has not been presented to the tribunal so that we can cross-examine him. We cannot even confirm whether this person exists or not, or what potential reason. As such, we believe that this exhibit itself is not credible and is not inadmissible. Thank you so much, Honorable Arbitrator.
All right. Maybe now proceed with the process further.
Much obliged, Honorable Arbitrator. With your permission, on behalf of the claimants team, Counsel Tasnim would like to submit the arguments and summations by claimant.
Yes, please.
Much obliged, Honorable Arbitrator.
With your Honor's permission, the Council would like to sum up the claimant's case in several points. First of all, COVID-19 vaccine falls under the permitted field of use of the claimant under the PCL agreement. Secondly, the claimant has abided by all the obligations under the PCL agreement. Thirdly, the respondent has violated confidentiality, good faith, and fair dealing of the PCL agreement. And fourthly, the respondent has caused the breach of the agreement. Last but not the least, as fifthly, due to such breach, the claimant is entitled to have general and specific relief. Honorable Arbitrator, moving on to the first point, that COVID-19 vaccine falls under the permitted field of use of the claimant under the PCL agreement. Honorable Arbitrator, permitted field of use in a licensing agreement, as mentioned and defined in the WIPO handbook, is the scope of the application of the invention by the licensee. And it is very clear that the respondents in the written statement and also the witnesses' statement have admitted that claimant has the right to produce the vaccine. Honorable Arbitrator, being within the limitation of the PCL agreement, the claimant has done a massive research already and found a very promising result in April 2020. Not only this, though a very small startup company with limited resource and manpower,
it has concentrated its sole work for production of COVID-19 vaccine by using Goretcam viral vector since 2020, which is almost 2 years now. So the threat of IP claim now on their sole field of research resulting from any activities of the respondent has posed the threat of the Gaspivec pharmaceuticals being destroyed. So today's decision of this arbitration is nothing but a decision of existence for the claimant. Honorable arbitrator, moving on to the second point, we submit that the claimant has abided by all the obligations under the PCL agreement. The claimant has performed and willing to perform his part under the agreement. As soon as we found the very promising result, we immediately communicated it to the respondent. As your honor can see in exhibit number 22, we are even ready to pay the price of the first batch. I would like to draw your kind attention as in the opening statement they have blamed that we did not buy the HEC 294, but and also we did not pay. But we are ready to pay for the first batch and achieved an additional time when respondent agreed and levied us extra time, as your honor can see in the emails shown in exhibit number 22 and 23. Honorable arbitrator, such performance by the claimant across the equitable principle of part performance and requires the respondent to perform their part as well. But contrary to this whole obligation, what the respondent did is the breach of confidentiality, good faith, and fair dealing, which the claimant submits as the third point. Honorable arbitrator, according to section 10.1 and 10.2 of the PCL agreement, the respondent is bound to maintain confidentiality, and also by the good faith clause, they are bound to maintain good faith and execute the agreement in good faith and to cooperate in all matters, including IP rights. Also, in the WIPO handbook, it is mentioned as the guarantee of know-how, but the respondents has violated all the obligations. And at one hand, they contracted and gave us the exclusive license to use the Goretcam viral vector for production of COVID-19 vaccine. On the other hand, what they did, they immediately after getting know about the promising result of the using of Goretcam viral vector for production of COVID-19 vaccine, they jumped to work with the Gauss Pharmaceuticals under the veil of their mother company. And they knew about the promising result by our official email sent to them with special mention to confidentiality, honorable arbitrator. And this is also supported by the newspaper article shown in exhibit number 34. Honorable arbitrator, I would repeat, this is supported by the newspaper article, but not our whole claim is based on the only one article. Even though we expressed our concern by several emails, but the respondent did not give any satisfactory answer. Honorable arbitrator, surprisingly, even the respondents have acknowledged and mentioned about different emails and phone calls they received from us. Statement of fact. Your honor can find the email showing concern from us in exhibit number 24, 25, and 26. Honorable arbitrator, moving on to the fourth point, the respondents have caused the breach of the agreement. At first, they have caused the breach of warranties given in section 11.1.2, 1.3, and 1.4 of the PCL agreement. They warranted that they're not a party to or otherwise bound or aware of any third party's claim on the licensed matter. They have also warranted that they are not aware of any third party's claim of intellectual property in the licensed matter. They are also bound by Article 42 of the UN Convention on Contracts for the International Sale of Goods to deliver goods free from any third party's claim of industrial property and intellectual property. But honorable arbitrator, the article published in Biopharma and shown in exhibit number 19, it was clearly shown that the respondents were in a contention about the same license with Gauss Pharmaceuticals since last of 2018, which is even before entering into the PCL agreement with us. Thus, the respondents have violated warranties given. Honorable arbitrator, your honor can also see in paragraph number 6 of page number 2 of the BIAC case that Mr. Padnaroy took over the negotiation of the claimant with respondent number 1 while he was still officially working with respondent number 2. But nowhere in the negotiation they mentioned about their contention with the Gauss Pharmaceuticals. And all this has ultimately frustrated the fundamentals of the agreement. Also, Article 25 of the UN Convention on International on Contracts for International Sale of Goods provides breach of a contract by any party as fundamental, which substantially deprives the other party of what he is entitled to expect under a contract and which cannot be foreseen by a reasonable person. Honorable arbitrator, by continuing negotiation by the respondents with the Gauss Pharmaceuticals has vitiated our expectation under the PCL agreement. Honorable arbitrator, as a sub point, we request the honorable arbitrator to order for the rectification of the purchase obligation. The purchase obligation made by the respondents is very peculiar to the common practice, and it is violative of Section 15, subsection 1 and Section 15, subsection 3, clause A of the Competition Act of Bangladesh 2012. And also this is treated as beyond law by the recent Patent Act of 2022. And it is also not commensurate with the concern of restraint of trade as warned in Article 40 of the TRIPS Agreement. Honorable Arbitrator, moving on to the submission of the respondents, they have unnecessarily harassed our witnesses and they humiliated us as the small startup company and just went out of mutual respect of a contract, Honorable Arbitrator. They have also mentioned, to sum up of the witnesses statement, they mentioned the father and son relation, Honorable Arbitrator, but this is a commercial arbitration, not a family relation. And in every commercial arbitration, everything is based on a contract, not inheritance, Honorable Arbitrator. And also, in the opening statement, they have mentioned that they have given the license to a sub company. This is my concern through you, question through you, Honorable Arbitrator, to them. What did they mean by sub company? Did they mean Gauss Pharmaceutical? Or they did, all of them are sister company working under the veil. They did not even entertain all of our concerns and issues and also substantiate their inertia to reply all of our concerns, Honorable Arbitrator. And as the Council has already mentioned that there only one exhibit, that is the effect, is faulty both in factual and substantial basis, and this is thus the claim of the claimant to drop this exhibit from the list of the exhibits. Another point to be mentioned, Honorable Arbitrator, is that they have referred and also their witness number, the sole witness has blamed us that for the invention of Pfizer, we could not make profit and thus claiming them. Honorable Arbitrator, this is just baseless and ridiculous. How did Pfizer come here? We are claiming of the using of Goretkam viral vector for companies established under Bangladeshi law, and Pfizer is not at all connected to this. Honorable Arbitrator, on the basis of this, the Council would like to move on to the relief portion. The Council, the claimant, requires the Honorable Arbitrator to declare that both the respondents number 1 and 2, that is Danville Limited and Vectorville Limited, has breached the pre-sale agreement. Secondly, that nothing but the specific performance of the contract can be the proper remedy for the claimant, and hence under Section 12, Clause C of the Specific Relief Act, the claimant is entitled to have the contract specifically performed. And thirdly, not only this, in addition to the specific performance of the contract, to have significant loss already suffered by the claimant under Section 19 of the Specific Relief Act, and also under Section 70 of the Contract Act of 1872. And before specific performance, it is our humble submission before the Honorable Tribunal to order for the rectification of the purchase obligation of the agreement, and to declare that the claimant has the exclusive authority to work on COVID-19 vaccine, and that all the liaison of the respondents with under the veil of the mother company should be stopped immediately. And last but not the least, if required, to hold the actual wrongdoers liable by piercing the corporate veil of the holding company, and held both the respondents Danville and Vectorville liable. Honorable Arbitrator, by this the Council would like to close its argument. Much obliged.
Honorable Arbitrator, with the part of Counsel Tasnim as to arguments and summations by claimant, we conclude our claimant's part. As the coordinator of the claimant's team, I would like to show our gratitude towards you for permitting us to present the arguments and claim in this arbitration proceeding. Thank you so much for permitting us. That's all from the claimant side, Honorable Arbitrator. Much obliged.
Honorable Tribunal Arbitrator, our witness maintained a strong stand, though they were harassing him for long 25 minutes, maybe more than that. I have to see my stopwatch, but they are saying we harass their witnesses. On reference to that, their witness just said that they handle so many research and projects with other companies, but then they're saying that they were just conducting sole research on Gore-Atkin viral vector. Honorable Tribunal their witnesses trembling nervousness while answering our cross-examine clearly ensures how irrelevant and baseless their claims are. Also, they are continuously bringing references like we don't know anything about them. We never said that they bribed or we gave them the permission to work with COVID-19 vector viral. Even if they had it, they didn't pay us the due money, which were at the contract. And they are saying that they asked extra time from us, which is not true at all. We didn't have any conversation about asking extra time. They don't know where to create the issue. And also on the topic of Pfizer is a company, is a giant, powerful company which delivers vaccines all over the world. So I don't know if they are referring to all the Bangladeshi laws just to showcase their wit. Apparently, they are unhappy because a mother company shared its resources inside the wall. We are always saying we shared it with our respondent number 1, not Gauss Pharmaceuticals. It's like they are furious because the husband's money is shared by the wife in household expenditure. Well, I apologize, but we have to keep the lights on, Honorable Tribunal. On our company, it's a venture for business for us as well. For granting them the license, we cannot solely stop all of our research and our projects inside our company. Examiner-in-Chief Counsel showed that this case is based on mere trivial doubt to dance on our goodwill and earn some money and compensate some loss which they suffered because of their lack of resource and means. Honorable Counsel, there's a maxim that says certainty is not overruled by doubt. If this is not, then definitely not by rumors. And we are always saying it's a rumors. We sent them the arbitrational affidavit, sworn affidavit, but I guess some technical difficulties happened on that. We'll follow up on that, and it can be submitted on a established judiciary. They could not clarify any relevancy, but repeating question to harass our witness and to just to nervous them, so he can't maintain his stance. As I said, he's not very familiar with this room or this ambience, and it happened it for God, so for long 30 minutes, but demanding 10 million again of monetary compensation, where we still owe them 5.5 and 7 crores of respective bills in accordance with the contract. Why don't they cut a sum up and pay us the 2 million extra? On top of that, we are losing our valuable time and projects that we could be for great changes in mankind, unlike them wasting both our and tribunal's time just to cover up their failure very technically using legal loopholes and burdening the tribunal arbitrational system. We are asking 1 million of monetary compensation for each of arbitrational days of this dispute and a written apology for affecting our goodwill in corporate. We might negotiate about retracting their license for further business years if they do not stop this nuisance soon. I would like to thank Honorable Arbitrator for cooperating us with so long, and thank you, BIAC, for arranging this competition.
All right. I am now proceeding to prepare my result. Thereafter, I will come and give my points, or you may take the picks, and then we will announce the results. Thank you so much. You have to bear with me for a few minutes.
So we are going to take 5 minutes for the arbitrator to prepare our results, and during this period, we will show a video introducing BIAC. We will wait for some time until the arbitrator prepares the results. So you can turn off the camera and the audio, but please wait till the arbitrator announces the result.
All right. Are you ready for the points?
Yes, sir. We
Definitely,
are.
Honorable Arbitrator.
Sir, if
Or
may,
are you ready for the result?
Yes,
sir, if I may
Yes,
request,
we're so excited.
Yes, sir.
Honorable Arbitrator.
I have decided to give the points first and then the result.
Sir, if I may request everyone to turn on their camera and for capturing a photo.
Yes, yes, please.
If I may request everyone present here, the faculty members, to also turn on their camera for a group photo. Okay, sir, I would like to request Adv Dinesh Kumar Bishnoi, arbitrator of this session, to declare the result along with his feedbacks.
I will declare the result later, but I will give the points first because that is more important for the furtherment and the upliftment of the standards in future. Now, we have to ask a question to ourselves that the advocacy is an art, is also a skill. And we have to be persuasive. So we have to persuade. And if we get into a mechanical rhythm, then we may not be able to persuade. And when we decide what should be our speed, we have to be conscious of the fact that while going for the speed and covering maximum content, we should not lose out on persuasiveness, convincing, and the material aspects. That is first point. The second point is, while cross-examining, though we have a lot of area to cover, but we have to be very decisive whether we need to ask this question or that question. It's an ocean, and no one is perfect. We learn every day and we refine our skills every day. Now, if we treat our witness during cross-examination as enemy, we are bound to be offensive ab initio, right from the word go. So what we are looking at, that if we speak, it means nothing. It has to come out from the mouth of the witness. So how do we get that out of the mouth of the witness? So what do? We have to rephrase, or we have to change the pattern of the question. And you may well be or well not be aware that maybe that witness is acting as a part of the strategy and is not willing to give you what you want. And similarly, the issue is that if we are citing something, if we are making a reference to some judgment, it is mechanical to just cite and forget about it, or to proceed. We have to, if we are citing, we cite, we mention, we quote, and then we must bring out some point out of it. It's no point that citing and running away and leave everything to the imagination. So if we are citing, then we say that in that case, in the similar facts or circumstances, the court arrived at this decision. Or court considered, having considered all the facts, the court arrived at such conclusion. So a line or two will be beneficial. Then the another point I have for you, that you have all the time in the world. And if you have not prioritized your points, then you will end up asking all irrelevant questions in the beginning and all pertinent and important and material questions at the fag end, or you may not have the time to ask those questions. So it's very, very important that you prioritize and hit at the nail right in the beginning. Otherwise, you will lose out, and your most important questions, which will be decisive in the case, you will have no time to ask those questions, or you'll be running. You'll be running against that time. Now, you and we have gone through now a phase of the competition, and we are more aware now. All parties, all participants, all teams. And we should be aware of the international standards, and we should be aware that, well, while the cross-examination is going on, you are well within your right to raise the objections, but then don't speak for the witness. And I have last point for you, that suppose the witness is behaving, you have to see the demeanor of the witness, whether if you start annoying him, he will give you all wrong answers. It will not help your case. You have to build your case based on the what's coming out of the cross-examination. And you speaking or you summarizing or you pleading means nothing, because it has to be tested during cross-examination. And if you have annoyed the witness, or if he's keeping quiet, as you have to ask this question to yourself. Suppose the witness is not forthcoming, he's keeping quiet, and he's asking you to repeat, or is not able to understand, or having understood he is behaving in that manner. So he is all within his rights. So you can't object to that. It is the witness who has to speak. So you have to support your story through the witness. And if you are offensive, and if you are pouncing upon him right from the word go, then you are not doing justice to your own case, because firstly, if you ask too many questions, the witness will go on tangent and tangent and tangent and tangent, and then it will waste your time. He will eat into your time. Maybe that is a part of the strategy. So you got to have these things in mind, and just give me, I have finished my point. Unless you have some pressing points, I'll give you 1 point each to each team. They can ask me 1 point each. 1 point the claimant can ask, and 1 question the respondents can ask me. If nothing, then I'll take half a minute and then I'll come back.
Honorable arbitrator, on behalf of the claimant side, we would like to ask regarding your 5th point on raising objection. How can the team decide as to when to raise objection? And you also stated about not to speak for the witness. So should we just raise objection regarding irrelevancy or assumption and then stop, or should we proceed a little bit more? Thank you, Honorable Arbitrator.
The correct procedure is that the opposite party and the party who's brought the witness, he is entitled to raise the objection. Any parties are entitled to raise objection. And then both parties are heard, and decision is given. Either it is overruled or it is sustained. And you are well within your right to object. There's no problem on that. Okay, next point. One point or question from respondent team, if they wish to ask.
Yes, Honorable Arbitrator, I have a little question that when the opposite counsel is asking too many questions for our witness, how to support him if he's trembling? Because I need to make sure I make justice to my case as well. I don't know how to respond to that.
Okay, now we, on behalf of the witness, we can't interject. On behalf of the witness, we can't speak. It is the witness who has to speak. It is the witness who has to support the story or oppose the story, or it is the witness who is being tested, who's being grilled. So everything has to come out of the witness, and then it is all preparations prior to the cross-examination. And part of the art of the cross-examination, I won't delve into that. I won't say that you have to interview witness or you have to prepare witness. That is not, I'm not propagating that, but I'm saying that you have to be very clear about the questions, and the witness need to know, and the witness is the best person to do the justice or otherwise. Thank you. Now give me just half a minute and then I'll come back.
Much obliged, Honorable Arbitrator.
All right. The organizers, can they confirm that they have received these score sheets? If yes, I'll announce the result.
No, sir, we did not yet receive the score
Okay,
sheets.
just refresh the mail.
Yes, sir, we have received.
Okay, good. Now, keeping in mind what points I have given you already, the respondents have taken an edge over claimants. It was a great pleasure and privilege being with you, and wish you all the best in your future endeavors. Keep in touch. Bye-bye. Do you want me to repeat or you have understood? Okay, may I have your permission to leave now if you have understood the results?
Yes, sir.
Okay, right. Bye-bye. All the best.
But if you guys please wait for a minute, we will announce the results.
Okay.
Congratulations to the team of University of Barishal for winning this round. And thank you to the team of University of Dhaka for participating. Everyone has performed brilliantly. I would like to conclude the session by thanking the chairperson of today's session and team members of University of Dhaka and University of Barishal, along with their faculty members who worked hard to train up and prepare their students for this contest. The University of Barishal has qualified for semifinals. Thank you for all joining us tonight.
Thank you,
Thank
BIAC.
you so much, Dhaka
Thank you,
University
BIAC.
team. We really had the hardest competition there. Thank you so much.
Congratulations, University of Barishal. You have qualified for semifinals. See you in the semifinals.
Thank you so much, ma'am.
Thank you.
Thank you.
You may leave the Zoom meeting.